Sir, you need to step away from the stage area right now.
I'm scheduled to speak. My name is on the program.
You are making a mistake.
You do not have clearance here. Step aside.
Until you verify, you're escalating without cause. This is a legal forum.
Either comply or we will remove
Verify or you'll regret this mistake.
The auditorium was already full when the voice cut through the low murmur of legal chatter. Sir, you need to step away from the stage area right now. The man holding a leather folder paused mid-step. He turned slowly, eyes moving from the uniformed security officer to the second man approaching from the aisle, a city police officer, hand resting near his belt. Not aggressive, yet I am scheduled to speak in 10 minutes. My name is on the program. You are making a mistake. The words did not calm the situation. They sharpened it. You do not have clearance to be back here. This area is restricted. Please come with us. Around them, the symposium continued breathing. Microphones popped softly on stage. A projector hummed. Pages of law journals flipped in the audience. This was the annual Constitutional Governance Symposium, a closed-door legal forum attended by federal judges, law professors, senior litigators, the kind of room where words shape precedent. And now, every head was turning. The man being stopped was black, mid-40s, tailored charcoal suit, calm posture, no raised voice, no sudden movement. His conference badge hung clearly from his jacket pocket, though no one seemed interested in reading it. I was invited by the organizing committee. I advise on constitutional review. Please check with them before escalating this. The security supervisor shook his head slightly. The decision had already been made. The officer stepped closer, subtly, angling his body to block the path toward the stage. Sir, we have received concerns. You are disrupting the event. A few rows back, a law student lifted her phone. Someone else whispered that this was ridiculous. Another voice said nothing at all. The man exhaled slowly. He looked past the officers to the stage where his name was printed beneath the keynote panel. The letters were large enough to read from where he stood. This is a legal symposium. You are detaining me without cause. On what basis are you removing me? The officer did not answer the question. He repeated the instruction. Sir, please come with us now. The folder in the man's hand tightened, not in anger, in calculation. He had spent decades navigating rooms like this, rooms where he had to be twice as prepared and half as visible. He understood the moment instantly. This was not confusion. This was assumption. As he was guided toward the aisle, the room grew louder. Chairs scraped. A professor stood halfway up, then sat back down. Cameras were now openly raised. The security team moved faster. What none of them knew yet, what no one thought to verify. The man they were escorting out of a constitutional law symposium was not an intruder. He was an advisor whose written opinions had crossed the desks of Supreme Court justices, and every step they took away from the stage was about to become evidence. The room disappears as the story rewinds. Long before anyone tried to escort him out of a symposium, he learned how to survive rooms that were not built for him. He grew up on the south side of Cleveland. Brick apartments, underfunded schools, a mother who worked nights as a court clerk and came home with stacks of discarded briefs she was not allowed to take but took anyway. He learned to read by sounding out legal language meant for adults. Habeas corpus, equal protection, due process. Words that sounded abstract until he watched neighbors lose homes and cousins disappear into the system. By 17, he was tutoring classmates. By 21, he was at the top of his class in a state university no one expected him to attend. He worked mornings at a copy shop, nights as a security guard, studied between shifts. Professors noticed his precision. He did not argue loudly. He dismantled arguments quietly. Law school followed, then clerkships, then years buried in constitutional research that never made headlines but shaped outcomes. He specialized in separation of powers, judicial review, the narrow margins where language decides lives. He wrote memoranda that were circulated without his name attached. He advised committees without being invited into the room. When a justice cited one of his arguments during oral proceedings, the credit went elsewhere. He did not complain. He documented. Over time, his reputation grew in places where reputation mattered. Chambers, advisory panels, closed-door briefings. He became the person judges called when a case was too sensitive to get wrong. He was never flashy. He did not chase panels or television time. He showed up prepared and left quietly. By the time he was invited to the symposium, his work had already influenced multiple high court opinions. His invitation email was formal. His role was clear. Advisory speaker, constitutional framework session. His badge was issued weeks in advance. Now rewind again. Not to his life, to theirs. The head of event security had been in private security for 11 years. Former military. Trained to assess threats quickly. Too quickly. His record showed multiple complaints from corporate events where attendees were questioned aggressively. None sustained. He was described as decisive, assertive, not great with nuance. The police officer assigned to the venue was on overtime detail, 8 years on the force, 2 internal reviews for unnecessary escalation. Both closed. He had learned that standing down looked worse than standing firm. When the call came from a junior staffer about a man near the stage who did not look like the other speakers, the language was vague, out of place, unrecognized, might not belong. No one checked the program. The security supervisor scanned the room and saw what his instincts told him to see: a black man with a folder moving confidently toward a restricted area. Confidence without permission reads differently depending on who carries it. The officer saw the same thing and felt the familiar tightening. A moment where authority must be asserted before it slips. By the time they approached him, they were not looking for information. They were looking for compliance. This is how systems fail. Not through malice, through shortcuts. Back in the present, as they guided him down the aisle, the past converged. Years of restraint, years of credentials proving insufficient on sight alone. Years of understanding that explanation rarely works once a narrative is set. He had prepared remarks about constitutional access and symbolic exclusion. He had not expected to become the example. Behind him, a professor whispered his name aloud for the first time. Someone finally checked the printed program. A staffer's face drained of color, but the damage was already unfolding in real time. Phones recording. Witnesses processing. Authority doubling down. Every step toward the exit added weight. Not just to his case, to theirs. Because this was no longer a misunderstanding. It was a documented removal from a legal forum without cause, by people trained to know better. And the consequences were about to match the credentials no one bothered to read. They reach the center aisle, and the situation hardens. He stops walking. Not abruptly, just enough to force the conversation back into words. I have documentation. Email confirmation. Advisory credentials. Please allow me to retrieve them. The officer shakes his head before the sentence finishes. You can explain this outside. Right now, you are delaying the event. He reaches into his jacket anyway. Slowly, deliberately. He pulls out his phone and scrolls to the email thread. The subject line is visible. Constitutional Governance Symposium. Advisory Panel. His name typed correctly. Dates. Signature block from the organizing chair. He holds the screen out. This is my invitation. This is my role. You can verify this in under 1 minute. The security supervisor does not look at the phone. He looks at the officer. The officer does not look at the phone either. He looks at the growing crowd. This is no longer about verification. This is about control. Sir, we have already instructed you to leave the restricted area. Continuing to argue is not helping your situation. Around them, the room has shifted. What had been polite discomfort is now visible tension. A law professor stands fully. Another whispers urgently to a colleague. A student in the back row narrates quietly into her camera. He lowers the phone, arguing. That word lands heavier than it should. He adjusts his grip on the folder. Inside are printed remarks on equal access to legal institutions. Case law citations. Footnotes. He had prepared for questions, not removal. I am not refusing. I am asking you to verify before escalating. That is reasonable. The officer steps closer. The distance shrinks to less than an arm's length. His voice drops. Sir, if you do not comply, we will escort you out. Escort, not remove. The language softens the act without changing it. A woman in the third row speaks up. Excuse me. He is listed on the program. I saw his name. The security supervisor turns toward her briefly. Ma'am, please remain seated. Another voice. Louder now. This is inappropriate. Phones are everywhere. No one is hiding it anymore. This is no longer a private misunderstanding. This is a public incident. He tries one more time. He reaches into the inner pocket of his jacket and pulls out a laminated advisory credential. Federal seal. His photograph. Title. Supreme Court Advisory Committee. Not something you can print at home. He holds it up. This is who I am. For the first time, the officer hesitates. Just a fraction of a second. Enough for doubt to flicker. Enough for him to glance at the credential and then away. He has already committed. I am not authorized to assess that. You can address it outside. The security supervisor places a hand lightly on the man's elbow. Not rough, not gentle either. Directional, possessive. They begin walking again. As they pass the first row, a judge recognizes him, stands up sharply. What are you doing? He is an advisor to the court. The words hit the air like a dropped gavel. Everything slows. The officer's posture stiffens. The supervisor's hand freezes mid-movement. A staffer near the stage pales. But momentum is a powerful thing. Stopping now would mean admitting the mistake publicly, in front of cameras, in front of peers. The supervisor speaks quickly. We will clarify this outside, and with that they push forward. Through the doors, into the hallway. The doors close behind them with a soft mechanical click that sounds far louder than it should. Inside the room, the symposium has stopped. Outside, the damage is accelerating, because now there are witnesses with credentials, video with context, and a removal that cannot be undone. And inside the folder, still in his hand, is a section titled Escalation and accountability. He did not expect to live it. The hallway is colder than the auditorium. Fluorescent lights hum overhead. The carpet muffles footsteps, but not tension. Each step away from the doors feels heavier than the last. Not because of resistance, because of consequence. They stop near a blank wall beside a framed evacuation map. This is where it becomes official. Sir, you are being removed from the event. The words are spoken calmly, procedurally, as if that makes them neutral. On what legal basis? The question is precise, measured, the kind he has asked in courtrooms and advisory sessions for decades. The officer does not answer it. He shifts his stance slightly, positioning his body between the man and the doors. You are refusing to comply with security instructions. Refusing. Another word, doing work it has not earned. He looks down at his hands, still holding the folder, still holding himself together. His breathing is steady. His voice remains even. I complied. I walked with you. I asked for verification. I presented credentials. You declined to review them. The security supervisor checks his radio. A low crackle. No response. He avoids eye contact. We will sort this out shortly. Shortly is undefined. Intentionally. Time stretches. A staff member appears at the end of the hallway, then stops when she sees the scene. She turns and leaves without a word. The officer takes out his notebook, begins writing. Not notes, just the motion. A signal that a report is forming. Sir, please place your belongings on the table. There is no table, just a narrow ledge beneath the frame. For what purpose? Standard procedure. Procedure without policy. Authority without explanation. He places the folder down anyway, slowly. The papers slide slightly. The top page is visible. Constitutional access and exclusionary enforcement. The irony does not escape him. The officer steps closer. His tone lowers. I need you to remain here while we confirm your status. Remain. Not detained. Not free. Suspended. A camera appears at the end of the hallway. Then another. People who followed quietly. Judges, attorneys, witnesses with understanding. Someone speaks off camera. This is unlawful. The officer looks over his shoulder. His jaw tightens. The security supervisor finally reaches for the badge clipped to the man's jacket pocket and turns it outward. Supreme Court Advisory Committee. The room does not exist. The words hang in the hallway alone. The supervisor freezes. The officer stops writing. For a moment, no one moves. Then the officer clears his throat. We need to contact a supervisor. That is the first correct thing said since the aisle. But it is too late for prevention. The harm has already occurred. Removal from a professional forum. Public. Recorded. Without cause. He says nothing now. He has learned when to stop speaking. Silence at this stage is documentation. A senior organizer rushes down the hall. Breathless, apologetic. She recognizes him immediately. This is a mistake, a serious mistake. The officer steps back. Just one step. Enough to change the geometry of power. We were acting on security concerns. Concern without threat. Action without law. The organizer looks at the badge, at him, at the cameras. We need to bring him back inside immediately. But the door remains closed, and in that pause, that fraction of hesitation, the injustice locks in place because removal is not undone by reversal, only recorded by it. And every second he stands in that hallway is another line in a case that no longer belongs to him alone. The confirmation does not come from the hallway. It comes from a phone call made inside the auditorium. A federal judge, steps away from the podium, and dials a number that does not ring for long. His voice is low, controlled, urgent. He does not explain the situation. He names the man. There is a pause. Then a response short enough to end the conversation. In the hallway, the air shifts before anyone speaks. The organizer's phone vibrates first. She answers. Her posture changes instantly. Shoulders back. Voice respectful. Eyes fixed on the man who has been standing silently beside the wall. Yes, he is here. Yes, he was removed. Yes, I understand. She lowers the phone slowly. Everyone needs to stop. The officer looks at her. The security supervisor looks at the officer. No one interrupts. This individual is a senior constitutional advisor whose memoranda are currently under review by the Supreme Court. He is not only authorized to be here, he was invited because of his role. The words land differently than credentials. Titles spoken aloud by authority have weight, paper does not. The officer's face tightens. He reaches for his radio again, but does not press it. The organizer turns to the man. I am so sorry. This should never have happened. The apology is sincere. It is also late. Another figure appears at the end of the hall. Older, calm. A federal administrator who has worked decades without spectacle. He walks directly to the man and extends his hand. I should have been here sooner. They shake hands. Briefly, professionally. Witnessed by cameras that have not stopped recording. The officer clears his throat. We were not informed of his status. The administrator does not look at him. You did not ask. Silence fills the gap between those sentences. The security supervisor steps back fully now. His hand drops from the radio. His voice is quieter. We acted on perceived access violations. Perceived by whom? No answer. The administrator turns to the organizer. The doors remain closed. Open them. Inside the auditorium, the room has been waiting without knowing it. Conversation stopped mid-sentence. Phones still raised. When the doors open, the shift is immediate. He walks back in alone. No escort, no commentary. Just the sound of footsteps returning across the carpet. The audience stands, not as applause, as recognition. The kind reserved for moments that matter. On stage, the moderator steps aside. The microphone waits. But the damage is visible now. It has form. It has witnesses. It has documentation. He places the folder on the podium, opens it, looks out at the room. Before beginning, he speaks one sentence. Quiet. Steady. What just happened is why this symposium exists. No one interrupts. Behind-the-scenes calls are already being made to departments, to supervisors, to legal counsel. The removal has been reversed. The violation has not, because verification came only after humiliation. Authority corrected itself only after exposure, and the system revealed its priority without saying a word. The officer does not return to the auditorium. Neither does the security supervisor. Their absence will be explained later. In reports, in interviews, in findings. For now, the truth stands fully formed. The man removed from a legal symposium without cause was advising the highest court in the country, and the people who removed him have just become part of a case study they were trained to avoid. The aftermath does not wait for the symposium to end. It begins before he leaves the stage. By the time his remarks conclude, 3 separate videos are already circulating. One from the back row, one from the aisle, one from the hallway, each from a different angle, each capturing the same truth. A credentialed legal advisor removed without cause from a constitutional forum. By nightfall, the footage crosses platforms. Law Twitter, legal journals, civil rights organizations. By morning, it reaches morning briefings and closed inboxes. The narrative is no longer controllable. The officer is placed on administrative leave within 24 hours. Not announced. Not defended. The security firm suspends the supervisor pending review. Statements are issued, carefully worded, non-admissions framed as concern. The advisor does not speak publicly that day. He does not need to. A formal complaint is filed 2 days later. Narrow, precise, alleging unlawful removal, violation of civil access, discriminatory enforcement of security protocols, failure to verify credentials, each claim tied to footage timestamps, each supported by witness affidavits from judges and professors who were present. The city responds with silence, then with counsel. Negotiations begin quietly, then break down just as quietly. When the lawsuit is filed, it is not dramatic. It is methodical. 34 pages. Federal court. Jurisdiction clear. Claims measured. Remedies specific. It names the city, the police department, the private security contractor. Supervisory failures included. Pattern allegations footnoted. The footage becomes evidence. The silence becomes evidence. The delay in verification becomes evidence. Public reaction follows numbers. 2 million views in 48 hours. Comments from law students who recognize the fear. From attorneys who recognize the procedure. From people who recognize as the pattern. An internal review confirms what the video already showed. No threat assessment, no access check, no attempt to verify credentials. Decisions made based on perception, reinforced by authority, escalated by ego. The officer resigns before termination. His record follows him. The security firm loses its municipal contract. The city settles before trial. The figure is not disclosed officially. Sources confirm it is substantial. Enough to hurt. Enough to matter. Enough to be noticed by risk management departments that rarely notice people. The advisor directs the settlement into legal access funds and civil rights education. He releases one statement. This was never about me. That sentence appears in briefs, in editorials, in classrooms. Policy changes follow, quietly. Mandatory credential verification at professional events. Joint authority, clarification between private security and law enforcement. Revised training materials citing the incident without naming it. The symposium changes its intake procedures. So do others. The room that removed him does not exist anymore. But its echo does, because justice did not arrive with applause. It arrived with documentation, with process, with consequences measured in careers and contracts. And the people who assumed authority without verification learned something the law already knew. That access, denied without cause, is not security. It is liability. What happened in that hallway was not a misunderstanding. It was a violation with a paper trail. From a legal standpoint, the failure began with access control. A professional symposium open only to credentialed participants still qualifies as a limited public forum. Once an individual is invited and cleared, removal requires an articulable reason tied to conduct, not perception, not discomfort, not appearance. In this case, there was none. The absence of reasonable suspicion matters. Security and law enforcement cannot lawfully detain or remove a person without a specific and objective basis. The refusal to verify credentials after they were presented is not a neutral act. It transforms uncertainty into discrimination. Courts have consistently held that failure to investigate readily available exculpatory information undermines any claim of good faith. There is also a civil rights dimension. Selective enforcement based on race violates equal protection principles even when the setting is professional and the language polite. Bias does not require slurs. It operates through assumptions, through shortcuts, through decisions justified after the fact rather than before the action. Psychologically, this incident illustrates authority escalation. Once a decision is made publicly, individuals in power often double down to avoid loss of face. This is why verification must come before action, not after exposure. Training that ignores this dynamic produces predictable harm. For viewers and attendees, the lesson is practical. Always document, record calmly, preserve credentials, ask clear legal questions, and note when they go unanswered. Silence after a rights assertion is often more powerful than argument. Witnesses matter. Names matter. Time stamps matter. For institutions, the lesson is structural. Shared authority requires clear protocols. Private security cannot substitute judgment for law. Law enforcement cannot rely on vague reports. Verification is not optional. It is the safeguard that prevents bias from becoming policy. And for the audience watching this unfold, the takeaway is uncomfortable but necessary. Even in rooms built around justice exclusion, can happen quickly and quietly. Credentials do not protect against assumption. Titles do not stop bias at the door. The system corrected itself only after harm occurred. That is not success. That is damage control. Real accountability happens earlier, when questions are asked, when verification is routine, when authority pauses instead of pushing forward, because the true measure of justice is not how fast a mistake is apologized for. It is whether it was allowed to happen at all.